Greetings from Edu Aspirants, our YouTube channel to ace academics, competitive exams, entrance exams, as also for enrichment of knowledge. In the series of our videos on India, in the following videos, we shall be covering law and justice. The Ministry of Law and Justice is Government of India's oldest, dating back to 1833, when the Charter Act 1833 was enacted by the British Parliament. It vested legislative power in a single authority, and that was the Governor General of the Council. By virtue of this authority and the authority vested under him under Section 2022 of the Indian Councils Act 1861, the Governor General enacted laws for the country, and this was for a period from 1834 to 1920. After the commencement of the Government of India Act 1919, the legislative power was exercised by the Indian legislature constituted thereunder. The Government of India Act 1919 was followed by Government of Act 1935. With the passing of the Indian Independence Act 1947, India became a dominion, and the Dominion legislature made laws from 1947 to 49, and under the provisions of Section 100 of Government of India Act 1935 as adapted by the India Provisional Constitution Order 1947. Under the Constitution of India, which came into force on the 26th January 1950, the legislative power is vested in the Parliament. Ministry of Law and Justice comprises three departments, namely the Department of Legal Affairs, the Legislative Department, and the Department of Justice. The Department of Legal Affairs is assigned legal functions including the interpretation of the Constitution and laws, litigation, legal profession, labor, law reforms, treaties and agreements with foreign countries in the matters of the civil law, legal services including Indian legal services, etc. The legislative department is concerned with the drafting of the principal legislation for the central government. The Department of Justice is concerned with the appointment, resignation, and the removal of the Chief Justice of India, the judges of the Supreme Court, and the High Courts. The Indian legal system comprises four components, which are the basic values and principles enshrined in the Constitution, rights and obligations conferred by the ordinary statutes, organizational setup to enforce these rights and obligations within the constitutional norms, and legal and the judicial personnel. India being a democratic country, there is a chain of accountability towards sovereign which lies in the people. The main sources of law in India are the Constitution, statutes, that is the legislations from time to time, customary laws, and case laws. Statutes are enacted by the Parliament, state legislatures, and union territory legislatures. Besides, there is a vast body of laws known as subordinate legislation in the form of rules, regulations, as well as bylaws made by the central state governments and local authorities like the municipal corporations, municipalities, gram panchayats, and other local bodies. This subordinate legislation is made under the ordinary authority conferred or delegated either by the Parliament or state government or the union territory legislatures. Judicial decisions of superior courts like Supreme Court and High Courts are important sources of law. Decisions of the Supreme Court are binding on all courts within India. Local customs and conventions, which are not against statutes, morality, etc., are also recognized and taken into account by courts while administering the justice in certain spheres. This is the Supreme Court. Enactment of laws. The Parliament is competent to make laws on matters enumerated in the Union list. State legislatures make laws on matters enumerated in the state list. Parliament alone has power to make laws on matters not included in the state list or concurrent list. On matters enumerated in the concurrent list, laws can be made by both Parliament and the state legislatures, but in the event of conflict, law made by Parliament shall prevail over law made by that state legislatures, unless the latter law, that is law made by a state legislature, is reserved for consideration of President or has received his assent, and in that event shall prevail in that state. This brings us to the end of the first video on law and justice. Keep revising the next video, and there will be 5-6 videos on this chapter, law and justice. Subscribe, like, share, and do press the bell icon for updates. Best of luck for your forthcoming exams.